Good evening, and thank you all for coming to tonight's panel discussion titled Notre Dame and the HHS Contraceptive Mandate. On behalf of Right to Life, I'd like to thank and introduce our panelists, and particularly our moderator, Professor Philpott. We'll start off by introducing Professor Daniel Philpott, who is Associate Professor of Political Science and Peace Studies, with academic interests in religion and global politics and reconciliation in politics, and author of the forthcoming book, Just and Unjust Peace, An Ethic of Political Reconciliation. Please join me in welcoming Professor Philpott.
Thank you very much. It's good to see such a wonderful turnout tonight for an event as important as this. So right now, I think some of my students are here from my class on Catholicism and politics, in which one of the recurring leitmotifs is the relationship over history between the church and the state. So we talk about the early church, when the church was fending off the Roman Empire. Even during the Middle Ages, when the church was established, it was fighting battles with the kings and temporal authorities over its rights over its own body, its appointments of bishops, and its governance of its various affairs. And then we look at a 500-year period from around the middle of the 1400s to the present, where I would argue that the state becomes more and more powerful vis-a-vis the church. Thus it is populated with figures like Henry VIII and the Jacobins of the French Revolution, and ultimately governments that even more aggressively have sought to snuff out the church. But one of the themes that emerges is that in America, we have a very unique and remarkable experiment in church-state relations, where we have a modern state, which in fact provided room for churches, Catholic Church, Protestant Church, members of other religions to flourish. And it proved to be a great shining example of religious freedom and how a modern state could be built around a vibrant, flourishing religious faith. Many people feel, however, that in recent years the direction has been going the other way, that there's been a move towards closure and towards increasing control and management of the church. And perhaps nothing signifies that so much and exemplifies that so much as the recent controversy over the contraception mandate from the Health and Human Services Department. The degree to which bishops have spoken out on this in the name of the church and its rights and authority is really has very little precedent. And thus the debate has been lively, it's been heated, but one that also many people are simply seeking to understand. And I couldn't think of any four better people to help us do that than the panelists who are with us tonight. So I'm going to introduce all four of them, and we'll allow each one of them to come up and speak for 8 to 10 minutes, beyond which point my cane will come out and rein them back in, so that we'll have plenty of time for question and answer where you can engage the panelists and engage the topic yourself. First we'll have Professor Carter Snead, who joined the faculty of Notre Dame Law School in 2005. His principal area of research is public bioethics, the governance of science, medicine, and biotechnology in the name of ethical goods. In addition to his scholarship and teaching, Professor Snead has provided advice on the legal and public policy dimensions of bioethical questions to officials in all three branches of the U.S. government and in several intergovernmental fora. You want an expert to explain things like embryos and implantation and things like that, there's no better person to turn to than Carter Snead. Prior to joining the law faculty here at Notre Dame, Professor Snead served as general counsel to the President's Council on Bioethics, where he was the primary drafter of the 2004 report, Reproduction and Responsibility, the Regulation of New Biotechnologies. He was recently appointed by the Director General of UNESCO to a 4-year term on the International Bioethics Committee, a 36-member body of independent experts that advises member states on bioethics law and public policy. It's taken into places like Kazakhstan, was it? Azerbaijan, yes, okay. So not that they're all the same or anything. I'm an international relations professor after all. Professor Snead received his J.D. magna cum laude from Georgetown University and his B.A. from St. John's College, and clerk for the Honorable Paul J. Kelly Jr. of the U.S. Court of Appeals for the 10th Circuit. He's also the father of 3 very cute adopted children. Professor Richard Garnett teaches and writes about the freedoms of speech, association, and religion, and also about constitutional law more generally. He is a leading authority on questions and debates regarding the role of religious believers and beliefs in politics and society. He has published widely on these matters and is the author of dozens of law review articles and book chapters. His current research project, Two There Are, Understanding the Separation of Church and State, will be published by Cambridge University Press. Professor Garnett is regularly invited to share analysis and commentary in national print and broadcast media, and he contributes to several law-related blogs, including Mirror of Justice, which I procrastinate with all too often myself, Prof's blog, and Law, Religion, and Ethics. Professor Garnett clerked for the late Chief Justice of the United States, William H. Rehnquist, during the court's 1996 term, and for the late Chief Judge of the United States Court of Appeals for the 8th Circuit, Richard S. Arnold. And in his spare time, he likes to climb mountains and run marathons to relax. Then we have Lisa Everett, who, along with her husband, Fred, has co-directed the Office of Family Life for the Diocese of Fort Wayne, South Bend since 1988, working in the areas of marriage preparation, natural family planning, education in human sexuality, pro-life activities, and family formation. Lisa studied in the Great Books program at the University of Notre Dame, receiving a Bachelor of Arts in 1985. She continued her studies at the John Paul II Institute for Studies on Marriage and the Family in Rome during the 1985-1986 academic year. In 1986, Lisa began her diocesan work as a research assistant to Bishop Darcy, John Michael Darcy, our previous bishop, in the areas of marriage and family life. She has served on various national boards and committees involving the areas of human sexuality and family life. She writes and speaks frequently on issues related to marriage, family, and building a culture of life. Fred and Lisa are also the parents of 7 children, 2 of whom, Thomas and Liz, I believe are here tonight. Tom is one of my victims in Catholicism and politics. Finally, Gabby Speach is a senior in the program of liberal studies with a minor in philosophy. She is happy to have finished her senior thesis. I'm happy as well because I was her advisor. And it was a fantastic thesis, one of the best I've ever advised. And she's truly got to keep your eye on Gabby. She's going to be doing great things in years ahead. The thesis was titled After Value, a Case for Keeping Dignity in Public Debate. And she intends to pursue a PhD in political science. She has been an active member of Notre Dame Right to Life during the past 4 years, and she was the editor-in-chief of the Irish Rover and is currently an assistant editor for Public Discourse, the online journal of the Witherspoon Institute in Princeton, New Jersey. So with that said, let me first introduce or ask Carter Snead to come to the podium.
Thank you very much, Dan. Thanks to my colleagues on the panel, and thank you for Gabby for putting this together, and thank you all for coming out in an evening and participating in this event. My role, I think, this evening is to give you some background information, mostly descriptive in nature, of what the contraceptive mandate is, what its legislative and political history has been and is. Again, this is unfolding as we speak, so that we can sort of set the table for a good exchange during the question period. So without further ado, let me just dive into my account of how we got where we are. So in March of 2010, you will recall that the Affordable Care Act was passed in Congress, and a major overhaul of the way healthcare is financed in the United States. And one of the provisions of the very large bill was a provision that required health plans to cover certain preventative services for women without cost sharing. Cost sharing is a term of art in the world of insurance and health law, which refers to out-of-pocket expenses for co-pays, co-insurance, or deductibles. So the idea is certain preventative services must be provided by health plans, by health insurance plans, to women without requiring them to pay out of pocket. But the statute didn't specify which services would be mandated. They instead deferred that judgment to the Department of Health and Human Services, who in July of 2010, just a couple of months after the passage of the bill, issued a rule that specified that a sub-agency of the Department of Health and Human Services, known as the Health Resources and Services Administration, would take a year and consult with various experts and come up with a list of preventative services that would be covered, that would be mandated to be covered without cost sharing. So the HRSA, the sub-agency of HHS, in turn delegated the task to a non-governmental body called the Institute of Medicine, which is one of the arms of the widely esteemed National Academy of Sciences. A year later, August 2011, the HRSA received the recommendations from the IOM, accepted those recommendations, and among the services that they proposed to be mandated or required to be mandated to be provided without cost sharing was, quote, all Food and Drug Administration approved contraceptive methods, sterilization procedures, and patient education and counseling for all women with reproductive capacity. So to summarize, all FDA contraceptives, sterilization methods, and different forms of education. And I should pause a moment here. We're talking about and what's referred to generally as the contraceptive mandate, but some of the drugs that are approved by the FDA, if you look at the FDA labeling, and I have one particular drug in mind, Ella, which is also called the week after pill, has certain, can function in certain interests, in certain contexts to cause the death of the newly developing human embryo, not just before implantation, but also after implantation. It's contraindicated for pregnancy, and it is, and the FDA labeling is very clear, and in animal studies, it results in the termination of pregnancies in different animal models. So there is a concern not just about contraception, but also the mandatory provision of drugs without cost sharing that can, in certain instances, cause the death of a developing living human embryo, which raises different moral and concerns alongside those that have been raised about questions connected to contraception and sterilization. So it's important to keep that in mind, although most of the discourse, and probably much of what we'll be talking about tonight, will focus on the contraceptives that are mandated for coverage without cost sharing. But it's important to keep in mind that there is not just a religious liberty objection to the mandate, but there's also what I'll call a pro-life objection, because it includes these kinds of drugs that have embryocidal effects. So, on August 3rd, 2011, the Department of Health and Human Services issued a rule that would authorize a very narrow exemption for certain religious employers from the force of the mandate to provide these drugs and procedures without cost sharing. And the narrow category of employers that would be exempted from application of the rule included employers that met all of the following criteria. The first criteria is that the entity had to have the inculcation of religious values as its purpose, as the purpose of the institution is to inculcate religious values. It had to primarily employ persons who share its religious tenets. It had to primarily serve persons who share its religious tenets. And finally, and these are all required, it's not in the alternative, but all four of these conditions have to be satisfied for the exemption to be effective. It has to be a nonprofit organization as defined by certain provisions of the Internal Revenue Code, which refer to churches, their integrated auxiliaries, conventions, associations of churches, as well as the activities, religious activities of any religious order. So it's a very narrow exception to the contraceptive I'll call it the contraceptive mandate for purposes of shorthand, eligible really only for those institutions that serve their co-religionists, that employ their co-religionists, and that qualify for that classification that I just outlined, namely churches, church auxiliaries, and religious orders, insofar as they're engaged in religious activities. So it's a very narrow exemption, and my colleague, Professor Garnett, will explore some of the normative entailments of that narrow exemption, and will likely compare it to other exemptions. But let's just say it's unprecedented, certainly in federal law, to ever have such a sweeping mandate with such a narrow exemption. And even if you compare it to state laws, there's only a handful of state laws that had a similar, in effect, had such a similarly narrow provision. So, immediately following this rule, there was a major backlash, a major political backlash, which united for a moment, in a sort of amazing moment, united Catholics from across the ideological spectrum. It's a unique moment when all Catholics agree on political questions, to be sure. And this was a moment in which Catholics on the left, Catholics on the right, Catholics in the middle, all combined to say this is too much. This is not an acceptable mandate. This violates religious liberty. This violates conscience. This impedes our capacity to witness to the truths that we affirm in an integrated and authentic way. And so, as I said, there was this moment of unity and solidarity across the ideological spectrum, not just among Catholics either, among evangelical Christians and Jewish folks and people and non-religious people as well, people who simply thought it was too much of an affront to principles of religious liberty and too much of a threat to institutional pluralism, which adds a great deal of richness to our society. And so there was this sort of this backlash. And the backlash was not just about the narrowness of the religious exemption. It was also motivated by a concern that entities would not receive any relief from the law if they were objecting to the mandate on non-religious grounds. If they had other moral objections to the provision of these agents, non-denominational entities weren't covered. Individuals with religious or moral objections were not covered. So it provoked a great deal of concern. And on January 20th of this year, the administration came forward and said, we're not going to change the rule. The final rule will be as it was written. We will, however, give a one-year temporary safe harbor period to allow entities such as Notre Dame, Catholic Charities, Catholic Relief Services, religious hospitals, religious social service agencies to find a way to comply, because none of them would satisfy the very narrow definitions that were involved in the original exemption. So, So the criticism intensified. Eventually, HHS came back and said, we're not going to change the final rule. We will, however, in the interim of this one-year safe harbor provision, by August of 2013, we'll come out with rules that will try to allow for certain religious organizations that are objecting but non-exempted to find a way to provide plans for their employers and their students that don't require them to directly pay for these items. In fact, they'll shift the costs, shift the obligations to the insurance companies, or in the case of an institution like Notre Dame, a self-insured entity, to try to find some arrangement. Although it's very much up in the air, it's very unclear how exactly they will police these entities from shifting costs back to the employer, and it's very much in flux. So that's where we are now, and I will turn things over to my colleague, Professor Garnett, to talk about some of the normative entailments of this situation.
Well, you're all in luck. My friend and colleague Carter Snead said about half of what I was going to say, so you're spared having to hear me say it as well. I'm grateful to Gabby and to the Notre Dame Right to Life for organizing this event, for including me. I know it's a beautiful evening out there, and I'm grateful to all of you for coming to hear our thoughts and to share yours. So I've been asked to speak about the religious freedom implications and dimensions of this preventative services mandate that Professor Snead just told you about. So my short remarks are about whether and why this mandate is in tension with our country's historical, constitutional, and legal commitments to religious freedom. These are questions of great interest and great importance to me as a scholar. They matter to me as a Christian. They matter to me, as I'm sure they do to many of you, as a citizen in a democracy like ours. I sent around, I imposed on you, I apologize, a copy of an op-ed that I did in USA Today a couple weeks ago, which sketched some of my views in this matter, and maybe you'll find that good reading material while I'm up here droning on. So because I'm a lawyer, I can't resist splitting hairs I can't resist drawing distinctions. And so I want to distinguish my question, the religious freedom question, from some other questions that I think have been confused with the religious freedom question in the public discourse. So first, I am not talking about whether we think the Affordable Care Act is good policy, or whether the insurance coverage mandate is constitutional, although the Supreme Court is obviously interested in that question this week. And I'm not talking about whether we prefer Democratic approaches to healthcare reform over Republican ones or vice versa. These are perfectly good questions, but they're different questions from the one that I'm interested in today, namely, whether religious employers should be exempt from the preventative services mandate. This particular question, in my view, shouldn't be, it isn't, a liberal or a conservative issue. As I see it, Democrats and Republicans agree and long have agreed that America's commitment to religious freedom is foundational and fundamental. And we should be able to agree about this, even if we disagree about the policy merits of the Affordable Care Act. Second, by way of distinctions, I'm not talking about, for today's purposes, the merits of the Church's teachings on sexual ethics or about the social and other effects of contraception. These are obviously important questions. Others can and will speak more usefully about them than I can. But my point is, it really shouldn't matter for purposes of the religious freedom question whether or not you are a Catholic, whether or not you embrace the Church's propositions about human sexuality and human dignity. Remember, it's always going to be the case in religious freedom situations that we're talking about the protection of minority views. The whole point of constitutional protections for religious freedom, the whole point of accommodations and exemptions and exceptions is to protect and respect minority views, unpopular views. And after all, the views of the majority and popular views, they don't need special protection through legal devices. A third distinction, I am not talking about the very important, often technical questions about whether it would constitute culpable cooperation with evil for Notre Dame or for some other religious employer to comply with the mandate. Smart people disagree about this question, and in a room that John Finnis is sitting in, it would be foolish for me to try to speak to it. But this question is different from the religious freedom question also, I think. The religious freedom of institutions like Notre Dame, of communities like Notre Dame, is not just the freedom to avoid being coerced into doing evil. Religious freedom also includes the freedom of Catholic institutions to bear witness to the truth of the faith and to act with integrity and to act coherently in accord with their Catholic character as they understand it. And I think our President, Father John Jenkins, made this point very powerfully in the letter that he submitted in response to the initial HHS announced rule. So my question, I want to very briefly mention three aspects of it, three aspects of this religious freedom question. First, is the mandate unconstitutional? That is, does it violate the First Amendment? My answer to this question is possibly. Second, is the mandate illegal? That is, does it violate a federal statute called the Religious Freedom Restoration Act? My answer, get ready for it, probably. And third, is the mandate inconsistent with our traditions and with our long-standing commitment to pluralism and religious freedom? And here I say, with uncharacteristic certitude, yes. Start with the Constitution. As you all know, our Constitution guarantees the free exercise of religion. And generally speaking, the court has told us, this guarantee does not mean that religious believers or religious institutions are entitled to exemptions from generally applicable laws. Some of us don't like the fact that the Supreme Court has said this, but it has. So the Constitution protects the freedom of belief, to be sure. It protects against discrimination on the basis of religion. But, as currently understood, it does not give people a right to disobey otherwise valid laws, even when they have religious reasons for doing so. If the speed limit is 55, it doesn't matter if God's telling you to drive 70, you've got to drive 55. So, how could the mandate violate the First Amendment? Well, there are two possibilities. First, the existence of some exemptions. And let's be clear, the Affordable Care Act is riddled with exemptions and waivers for all kinds of institutions. The existence of some exemptions can mean, courts have told us, that religion-based requests for exemptions are entitled to similar treatment. That is, if the government is willing to exempt some people for some reasons from a generally applicable law, well, the question obviously is raised, why won't it exempt religious believers for religious reasons from that same generally applicable law? A second way that the mandate could violate the free exercise clause would go something like this. The current very narrow exemption that Professor Snead told you about is regarded by some, and I think with good reason, as basically reflecting kind of a picking and choosing among religious institutions. Some institutions are really religious. They're focused on the inculcation of values. They hire only their own. They serve only their own. It's good Sunday morning religion. Whereas other entities are, they're going out into the world. They're feeding the hungry and clothing the naked and visiting the imprisoned, and they're not quite as religious as these other ones. That kind of picking and choosing, in some cases, has been regarded as suspect religious discrimination. Well, let's put aside the Constitution for now. What about federal law? The Federal Religious Freedom Restoration Act is a statute that was enacted with broad bipartisan support. In fact, it's been characterized as reflecting a quote-unquote orgy of bipartisan support in Congress. It provides more protection for religious objectors than the Constitution does. It gives more protection to those who object to generally applicable laws than the Constitution does. Under this law, any statute that burdens religious belief or practice is subject to what we law geeks call strict scrutiny, which means that the government has to show that it has a, quote, compelling reason for imposing the burden and that less burdensome alternatives are not available. And in my view, the mandate fails this standard. Even if we concede, and I assume some of you would want to, that the preventative services mandate serves an important public interest, even if we concede that, it is clearly the case, in my view, that there are less burdensome ways of pursuing this interest that don't involve imposing suspect burdens on religious exercise. The federal statute says that if that's the case, then the federal government has to choose the less burdensome activity. So my view is that the mandate is vulnerable on Religious Freedom Restoration Act grounds. But finally, let's forget the Constitution, and let's forget the statute, and let's just look at our tradition, our American tradition, our experiment with religious freedom. Let's assume that the mandate's constitutional. Let's even assume that it's legal. This doesn't mean that it respects religious liberty or that it's consistent with our traditions of accommodating minority views. Sometimes a democracy like ours, with ideals like ours, accommodates religious freedom even when it doesn't have to. It does it because it thinks religious freedom is valuable and that religious pluralism is a good thing because it respects religion-based objections to even generally applicable laws. So in this case, it seems to me, the better policy, the policy that would better implement our commitments to religious freedom, would be to provide a broader religious freedom exemption to the preventative services mandate. And there's nothing preventing the HHS from providing such a broader exemption. But one final thought. As you've heard, there's been a compromise, been characterized as a compromise, proposed by the administration that could, in the months to come, end up tweaking the mandate in such a way that the payment mechanism is changed and so on. One thing to keep in mind, that I hope you'll keep in mind, is that even if this proposed accommodation goes through, even if it is implemented, it will still be the case that the religious employer exemption in the law is unprecedentedly, if that's a word, narrow. And to have that narrow exemption codified in our regulatory apparatus, it's like leaving a loaded gun around for a kid to pick up. That very cramped and crabbed understanding of what counts as a religious employer will come back to do damage in other contexts. It's not healthy for religious freedom generally for there to be in law, in this particular law, a definition of religious employer that is so narrow, so crabbed, and so cramped. So thanks, and I look forward to your questions.
Well, good evening, and I'm very grateful for the invitation to offer a few reflections on this panel from the perspective of a woman, a Catholic, as someone employed by a Catholic organization, namely the Diocese, and last but not least, as a mother, and especially a mother with a daughter at a Catholic university. For, as you may know, the HHS mandate has now been expanded to include free contraceptive coverage for their female students. So first of all, what is so galling to me about this mandate is that it flies in the face of the free exercise of religion guaranteed by our Constitution. A free exercise which necessarily includes the right to refuse to participate in activities that one considers morally wrong. Our nation has always respected this right as the granting of conscientious objector status to someone who cannot in good conscience participate in warfare bears witness. When I myself was a student at Notre Dame, I had a good friend who started out in ROTC and by his senior year decided he could not in good conscience continue to serve in the military and applied for conscientious objector status. And I was glad that he had that right. The HHS mandate, on the other hand, represents a dangerous and dramatic departure from this precedent, for it would force religious employers, whether institutions and just as importantly individuals, from participating in practices that they consider gravely immoral, without the possibility of opting out, so to speak, on moral or religious grounds. Another foundational principle of our democracy that is being flouted in the implementation of this mandate is that of equal treatment under the law, as Professor Garnett referred to a bit ago, given especially to me the fact that the Obama administration has granted the Amish community an exemption from observing the entire healthcare law. As Sister Mary Ann Walsh, who is Director of Media Relations for the United States Conference of Catholic Bishops, recently commented, quote, "The government respects the First Amendment that guarantees the right to freely exercise one's religious beliefs, but only to a point. In the healthcare law, it picks and chooses which beliefs it respects. The Amish do not believe in insurance, and the government understands. Christian Care Ministry believes people should form a religious community and pay medical bills for one another, and the government says, okay. Yet when the Catholic Church opposes being forced to pay for services that violates its beliefs, the administration says, tough." What underlies this unequal treatment? Why does the administration seem to respect the beliefs of certain religious groups but forces others to pay for practices to which they conscientiously object? I believe that the answer to this question lies in the conviction of those currently in power that contraception, sterilization, and abortion-inducing drugs constitute essential preventative services which enhance the health and well-being of women and which they are therefore entitled to receive for free, be they adult employees or college students. In the administration's mind, this right of women trumps any right that religious employers might have to refuse to pay for such essential services. Therefore, I would like to challenge the unquestioned claim which underlies the HHS mandate, namely that contraception, sterilization, and abortion-inducing drugs are preventive services which advance the health and well-being of women. The first point we need to make clear is that while there are rare medical conditions which can be exacerbated by the demands of a pregnancy, pregnancy itself is neither a disease or an illness. Therefore, to put the prevention of pregnancy in the same category as the prevention of illness and disease is both unreasonable and, I would say, offensive. What distinguishes women most from men is precisely our capacity to bear and nurture new life. And to treat this privilege as if it were some kind of pathology is an affront to our dignity as women. This is most obvious in the case of abortion-inducing drugs such as Ella, which Professor Snead referred to a bit ago. To force an employer or a university to provide health coverage which includes free drugs which induce abortions is a gross violation of religious liberty, and I would add a rejection of our unique role as women. However, what is more, the purpose of health care is to preserve or to restore the proper functioning of the human body, not to suppress or destroy one of its normal, natural functions. In fact, when a woman's natural fertility is suppressed through hormonal contraceptives, which are by far the most effective contraceptives available today, her health is neither preserved nor enhanced, but actually endangered. Many women do not realize, for example, that in July of 2005, the World Health Organization, International Agency for Research on Cancer, announced that after a thorough review of the published scientific evidence, combined estrogen-progestogen oral contraceptives and combined estrogen-progestogen menopausal therapy cause cancer in humans. This classification as a group 1 carcinogen put oral contraceptives into the same category as asbestos, arsenic, tobacco, and mustard gas, to name a few. Now, while the classification of hormone replacement therapy as a carcinogen made headline news around the world, unfortunately for the more than 10 million American women who take oral contraceptives, hardly anyone reported that the same press release also classified the combination pill as a carcinogen. In fact, the pill continues to be the most popular method of contraception in this country, especially for women under the age of 30. A little over a year after the World Health Organization announced its findings, the prestigious medical journal Mayo Clinic Proceedings published a meta-analysis of 34 studies conducted since 1980. The analysis concluded that women using oral contraceptives have a significantly higher risk of developing premenopausal breast cancer, especially if they are used for 4 or more years prior to a woman's first full-term pregnancy. Again, think college women. Even more recently, a 2009 study funded by the National Institutes of Health found that a year or more of oral contraceptive use was associated with a 4.2-fold increased risk of triple-negative breast cancer for women 40 and under. In addition to increasing the risk of breast cancer, the pill has been implicated in several other serious health risks, including cervical cancer, blood clots, heart attack, stroke, increased risk of acquiring HIV and other STDs, and doubling the rate of aging of a woman's cervix, contributing to infertility. And in case we think that these kinds of adverse health effects are limited to the pill, consider the fact that about 130 deaths have been linked to the birth control patch so far, and over 2,400 women have claimed that the patch caused them to have blood clots that resulted in heart attack, stroke, or pulmonary embolism. These claims have led to settlements already totaling over $68 million. According to the FDA database, NuvaRing has caused only 40 known deaths so far, but the manufacturer is facing 730 lawsuits for blood clot-related injuries and deaths. Now, to me, as a woman, in light of all this published research, all of which is easily accessible on a 30-second search on the internet, can we really take seriously the Obama administration's claim that forcing employers to provide free contraceptive drugs fosters the health and well-being of women? That the Department of Human Services would either be unaware of this research or worse, deliberately discount it, to me as a woman is unconscionable. And this, again, I think, is where ideology trumps the truth. In stark contrast stands the Catholic Church, which speaks the truth in season and out of season about the twin purposes of love-giving and life-giving, which God has inscribed in the marital embrace, purposes which we must not separate on our own initiative. But what is good for women, spiritually speaking, is also good for us physically. And the natural methods of fertility regulation, which the Church not only approves but promotes, and many others promote, not only do not pose any health risks, but actually can be used to monitor and maintain our reproductive health as women. When a woman is taught to identify and interpret the biomarkers which indicate the proper functioning of her reproductive system, she is also empowered to detect early on any abnormalities. The Creighton Model Fertility Care System, developed by Dr. Thomas Hilgers, director of the National Center for Women's Health, is a particularly specialized method of fertility awareness which can aid in the diagnosis and treatment of an array of women's reproductive disorders. In addition, our diocese and many other groups offer instruction in the symptothermal method of natural family planning, which, according to a 2007 report in Europe's leading reproductive medical journal called Human Reproduction, research has confirmed that if used correctly, that symptothermal method of natural family planning is as effective as the pill for avoiding pregnancy. And if that is not real reproductive health care for women, I don't know what is. In saying this, I do not claim to speak for every woman, of course, or even every Catholic woman, but I do take my place proudly beside the first feminists, those prophetic and pioneering women of the 19th century who condemned both contraception and abortion as offensive and injurious to women, and who called men to mutual respect and self-restraint in marriage as a way to regulate conception. I also stand with the more than 18,000 women who have signed an open letter to President Obama, Secretary Sebelius, and the members of Congress in support of the Catholic Church and its rich, life-affirming teachings on sex, marriage, and family life. We call on President Obama and our representatives in Congress to allow religious institutions and individuals to continue to witness to the faith in all its fullness, confident that it is precisely this faith that protects the dignity of women and promotes our best well-being, body and soul.
Before I get started, I just want to say thanks to all of you for coming, and thanks to our panelists, and I'd also like to say a special note of thanks to Catherine Remley, a friend of mine who's been extremely helpful in putting this together, so thanks, Catherine. My fellow panelists have already addressed for you tonight the fact that if the mandate is not overturned, religious liberty is the primary issue at stake here. But what I want to talk about with you a little bit is the way that the public debate about this mandate is currently framed, which is as a debate between supporters of religious liberty on the one hand and supporters of women's reproductive health on the other. Female advocates of the mandate have recently charged that to oppose the mandate is to wage war on women, to support a violation of women's reproductive justice. They've suggested that there are 3 injustices that will be resolved if employers with religious or moral objections to contraception are required to provide insurance plans that cover these services for their employees. The first issue that they say will be resolved is a lack of health care. Women will now be able to access a form of health care that they've previously been denied. The second issue is unequal access. Women are now going to be able to get reproductive services if they can't afford them just as easily as other women who can, or who work for institutions that cover contraceptives in their insurance plans. And the third issue that these women are saying will be resolved is that women who up until now haven't been able to get contraceptives for non-contraceptive reasons because they work at a place like Notre Dame will now be able to get them. And this third point is false, and I'm going to correct that later on. None of these arguments strongly supports the case that opposing the mandate violates or offends women's reproductive justice. And this is because these arguments do not accurately describe healthcare, and they don't accurately address the reality about access to contraception, which is it's easily accessible. First, and Mrs. Everett already touched on this, contraception can't properly be called a form of healthcare. The Obama administration and supporters of the mandate have tried to make contraception sound less controversial and more appealing as an entitlement of justice by labeling it a service for women's health. But we consider what is healthy to be normal biological functioning. When we are sick or injured, it means that some part of our body isn't working correctly. But on the contrary, when a woman is fertile, it simply means that she has matured and developed normally. When she's pregnant, it means that the sexual act between her and a man during a time of fertility has produced one of the natural outcomes at which that act is directed. Based on our standard conception of health, then, fertility and pregnancy cannot be labeled diseases that need a cure.
and fertility and contraceptives are not medicines that cure fertility and pregnancy. Second, unequal access to contraception is not enough of a problem to require that all institutions cover contraception in their insurance plans. As Kathleen Sebelius herself has noted, contraception is widely available at community health centers, public clinics, and hospitals with income-based support. Contraception is also easily available at local drugstores and from doctors. And the cost of contraception doesn't stop women from getting it. Generic contraceptives are available for anywhere between $9 to $15 per month at your local drugstore or pharmacy. And in many states, Medicaid covers the cost of contraception for women, for both from low-income backgrounds, and some states have actually requested and gotten permission for women of higher income backgrounds who don't meet the eligibility requirements for Medicaid to get these contraceptive services by waiving the requirements for them. In 2009, a study done by the Kaiser Family Foundation showed that a 44-state survey, 41 always covered several forms of prescription contraceptives, including oral contraceptives, intrauterine devices, implants, injections, diaphragms, under Medicaid. And finally, Title X clinics are federally funded clinics for family planning services that exist in all 50 states across the country, and their purpose is to fund contraceptives for women of low-income backgrounds. And third and finally, it is false that women and/or female students at religiously affiliated institutions cannot get contraception if they need it for non-contraceptive reasons. Even the U.S. Catholic Council of Bishops' Office offers this kind of coverage to its employees, and so does Notre Dame for its students and its employees. If you need contraception for a medically necessary reason that's not a contraceptive reason, you can get it here. So-called lack of health care and unequal access turn out to be poor defenses for requiring that all employers, with few exceptions, be required to comply with the mandate. In other words, those who say that my opposition to the mandate threatens reproductive justice for women don't have a strong case to make. As a woman, I don't see protesting the mandate to be a violation of my reproductive health. And again, as Mrs. Everett said, I certainly can't speak for all women, and I can't speak for all women students at Notre Dame. But I am joined in this opinion by, I think it's actually now more than 23,000 women who signed this letter, started by law professor Helen Albright, called "Don't Claim to Speak for All Women." It's clear to me and to these women that the Obama administration, under the guise of a preconceived idea of reproductive health, they're using this idea to show that there's really not a they're making reproductive justice, they're trying to make that a sound basis for restricting our freedom to honor our religious and moral commitments, and this is not the case. We would agree that the administration's primary goal behind this mandate is to ensure that people with a religious or moral objection to contraception are forced to cooperate in making contraception a public good. And besides, if women's reproductive health is really the primary issue at stake here, then we might ask why, in 2013, nearly 88 million employees will still be without this coverage because their employers have been exempted on purely secular grounds by the Obama administration from this mandate. There will be 55% of large employer plans that won't cover these services for their employees and 34% of small employer plans. The bottom line here is that whether or not we see contraception as immoral, the state is still unnecessarily forcing people with moral and religious objections to contraception to cooperate in promoting its use. Contraception for non-medical reasons is not healthcare, and equal access is not a problem. To say that opposing the mandate wages war on women is to twist the rhetoric that would be better used to describe the mandate itself, which is a needless battle against men and women alike who deserve to witness freely to their beliefs. Thanks.
Thank you to each one of the 4 panelists. We now have about a half an hour at our disposal to engage in public conversation and question and answer. And so I'll just go around the room and recognize questioners as you raise your hand. I only ask that you make your question indeed a question and not a speech. If you'd like to, preferably direct it to one of the panelists, but if you'd like to ask it in a more general way, that's fine too. Who's first? Yes, Angela, yes.
The question is directed toward Professor Garnett. What are the religious liberty implications for individuals who may have, they own an aluminum siding company, but they happen to have religious or moral objections to the contraceptive mandates? Would your comments apply to them equally as they would to Notre Dame?
Yeah, so that's a great question. As I think you picked up, both the existing mandate and the proposed compromise, which might come into effect down the line, do nothing for religious individuals who object to complying with the mandate. Most of the focus, most of the discussion has had to do with employers, and specifically with religious employers. And you're right, that leaves out a whole lot of other people who might have religion-based exemptions. As I see it, the Religious Freedom Restoration Act provides a strong argument both for institutions and for individuals to attack the mandate. That is, the mandate burdens the religiously motivated practice and exercise of individuals and of non-religious employers, just as it does of religious institutions. It does seem to me, I'll admit, that the case is even stronger for religious institutions that have a character, an identity, a mission. But I certainly wouldn't want to be heard to suggest that it's only religious institutions that have a religious freedom claim and nobody else. Politically, it's probably the case that exemptions are more likely to be secured by religious employers than by individuals, but that's another matter.
Philip.
I'll follow up on Angela's question. If all your arguments extend to individuals as well as organizations, that is, the mandate is burdensome, freedom of religious organizations, freedom of religious individuals, therefore religious individuals with moral and religious objections should be exempt. If anyone who has objections to the law should be exempt to the law, the implication is the calling for the law to repeal. That would be the only just solution. If you say, but we'll settle for just some religious exemptions, in arguing for religious exemptions for some, but not for all, aren't we selling out the individuals who won't be able to get them?
I don't think I'm doing that, and even if I were, I guess I'd say the answer is no. So the first point would be to say that I think you can argue for religion-based exemptions for all, and by all I mean institutions and individuals alike, under the Religious Freedom Restoration Act, without arguing for the repeal of those statutes that burden religion. I mean, the very premise of the Religious Freedom Restoration Act is that Congress thinks it is possible, often, to exempt religious believers, institutions and individuals, from otherwise generally applicable laws. So I don't think we're arguing for repeal. In terms of the kind of the throwing under the bus objection, I do think, this side of heaven, you do the best you can. And there are certain political realities. And one of those political realities is that we are far more likely to be able to secure exemptions for religious employers, broad exemptions for religious employers, than we are for just kind of every person who wants to opt out. I agree with you. I think that in principle and under the Religious Freedom Restoration Act, that individuals have as strong a claim to justice as institutions do. But I don't think it's immoral or unjust or hypocritical or anything for, again, in the messy world of politics, this side of heaven, to be focusing on the needs of religious employers.
I'm just going to add one thing very briefly to what Professor Garnett said. It's important to remind ourselves as we get into this discussion about religious liberty that the effect of the mandate is not simply to involve religious institutions in some way in the provision for free of contraceptives and sterilization. There's a separate, an entirely separate and analytically distinct, though related objection that one would have that I think would have to apply to every individual and call for repeal of the mandate, which is to say the mandating of the provision of abortifacient drugs for free. That's something that I think that we need to keep separate from our discussion, and the bishops and others who have objected to the religious liberty violations that are embedded in the mandate have a more robust criticism, I think, of the abortifacient mandate.
I was just wondering if you could clarify what would constitute a religious objection for an individual, and like what defines a religion necessarily.
Well, guys, that's a great question, and it's huge, and I can't answer it here. So in all laws that provide exemptions or accommodations for religious believers, the question is always raised, what counts as a religion, what counts as a religion-based objection? And the court's answer has been consistently and exquisitely vague, which is kind of a, we know it when we see it, come on, it's religion, you know what, blah, 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 right? It is a premise of our law that some motivations for wanting to get exemptions from laws are different from others, that religious ones can and should be treated differently from others. When we actually try to operationalize this commitment, we run into difficulties. And our general practice in America, to our credit, I think is to have had a pretty broad understanding of what counts as a religious objection, to not want to get into confining religious freedom to religious traditions that look like ones that we're familiar with, right? And I think that's appropriate. Does that mean it's possible for people to abuse religious freedom protections, to make bogus claims? Yes, it happens all the time. And that's, in my view anyway, kind of the cost of doing business in a liberal democracy that's committed to religious freedom. I think that's the best I can do.
Just add something very briefly. That one thing to be clear about, the Affordable Care Act does take a position on not only what constitutes religious views and practices, but distinguishes between certain kinds of religious employers and others. So they offer an answer that say, as Professor Garnett said, if you're really religious, if you stay in your cloister and only employ people that agree with you and only serve people that agree with you and qualify for the Internal Revenue Code classification that I mentioned. The other interesting feature of the Affordable Care Act is there is an exemption from the individual mandate, not the contraceptive mandate, but the individual mandate. That is the requirement that every person with some exceptions, carry a minimal amount of insurance coverage. And as Professor Garnett said, that was argued today. The constitutionality of that was argued today. Well, with respect to the Amish, who have been exempted from the individual mandate, and other categories of individuals as well, there's a footnote in the Affordable Care Act that says in order to qualify, you have to have a genuine belief in a religious tenet that forbids the acceptance of insurance coverage or the purchasing of insurance coverage. And not only that, you have to have declined to participate in other programs such as Medicare and the Social Security laws, and you have to have been in existence since 1950, which is another interesting provision. So they're very specific about what kinds of religions qualify for the exemptions from the individual mandate as well as from the preventative services mandate.
I am actually a supporter of the law. I think that it does good things for women, and so from my point of view, and the question to you is, in your opinion, what would be the appropriate way for the Obama administration to handle this problem? Like, how would then make all religion freedom people organization happy? Like, who they should exempt? Like, to what extent they should exempt, so that we don't have this discussion on religion's freedom, rather than the discussion is on the policy itself.
Okay, good. Thank you guys. Cheers.
I'm terribly sorry. I just could not understand the question.
I think the question. Tell me if this is correct. The question was, what would you do? What would be an acceptable alternative policy?
Exactly. So what would the administration do that would make the religion's freedom supported, satisfied? So I mean, like, what would the administration do so that the religious freedom argument is not an argument? So what could be done?
Well, the first thing that occurs to me is that each employer, be they an individual or institution, could cover methods of family planning in their insurance coverage that accord with their moral principles. For example, our diocese provides insurance coverage for methods of natural family planning. That's not to say that we're opposed to family planning. It's the method. There are methods that are in accord with our moral principles. There are methods which are clearly opposed to our moral principles. So, this is off the top of my head, but to me, one possibility would be to have employers offer insurance coverage for family planning methods which accord with their moral principles. And that our diocese, many other dioceses already do, for example.
Another option, sorry, go ahead.
Sorry, that's not exactly my question. My question is that if we assume that the policy is a good one, right? So, because in a society, a lot of people have to make compromises. So there's some policy that some people might agree with and some people might not agree with. And so if to a society at large, this policy is good, right? What could the administration handle so that the opponents would leave the argument of the religious freedom is no longer an argument, right? So how could that be handled?
Well, one thing is that there's precedent, right? For how the federal government can subsidize access to contraception. As Gabby said, Medicaid in most instances covers contraception. Title X subsidizes contraception. It's not my place to tell the administration how they can subsidize contraception, but that being said, if there were a generalized religious exemption, if religious institutions could opt out, or even people of conscience could opt out based on their firmly held moral objections, there could be a direct tax credit, for example. The bizarre thing to me about this entire enterprise is that 9 out of 10 insurance policies cover contraception. We spent $2 billion last year in fiscal year 2011 to cover domestic family planning services through Medicaid, Title X, and so on. And yet, this mandate operates by trying to shift the costs, at first to try to shift the costs to religious institutions that don't qualify for the narrow exemption. They're talking about ways of maybe shifting the costs away from that to insurers or to third-party administrators for self-insured entities, but it's not clear how that will work. But in any event, it's just a strange thing that this is where they begin. They begin by trying to co-opt the insurance plan of the institutions, the employers themselves, when they could simply do it directly. They could mandate the provision by Walgreens of oral contraceptive for free. They could give tax credits to people to pay for contraception. There are a million ways that you can. This goes to Professor Garnett's issue about what the least restrictive means is of pursuing this goal, if you think the goal is a good one. The idea is you don't have to go this route. You don't have to involve employers at all in this process. And I think that would satisfy the religious liberty objections of people. It wouldn't satisfy the more normative objections that were discussed by Lisa and Gabby with respect to the wisdom of the goal itself.
Yeah, one reason I think your question is so important is because it reminds us that a lot of times these religious freedom clashes are really difficult or even tragic because even though we respect religious freedom, we can't accommodate the religion-based objections that everyone has. In some cases, the policy goal is too important or the cost of accommodation would be too high.
It's intrinsically ideological to decide the definition of health, to figure out what counts as health and what you're going to cover, what you're not. Because that's politics. And politics not in the low sense, but in the high sense. We have to figure out how to govern ourselves and what sorts of decisions and distinctions we're going to draw in this context. And to suggest that it's simply a neutral exercise to pick out of thin air by virtue of the principles of public health and medical science what we should cover for free, I think that's a misleading at best conception. So the problem is there was not consultation with the ILM and these entities. There is some selective consultation with certain religious institutions at the moment, and there's discussion and dialogue, one hopes, with HHS and the White House, although what one hears from various sides as things leak out about those conversations is not encouraging.
But if they exempt X number, then they're going to end up without any way to fund it. Is that?
Well, their argument is it's revenue neutral. Their argument is that, in fact, it doesn't cost anything to give contraception for free, because if you compare the cost of preventive pregnancy with pregnancy, that in fact it's revenue neutral. They would argue that although no insurance company has yet figured this out, despite the fact that they're widely considered to be bloodsuckers who will sell their own mothers to make a profit, they haven't yet figured out that this is a way for them to save money, which I think is an interesting observation.
Well, one thing is for sure, and that is the issue will continue to be played out in various arenas. It would be played out in the courts where there are challenges pending. It will be played out in the Congress where early efforts to change it were defeated, but others are on the way, and it will be played out in the national election in the fall. Please join me in thanking our 4 panelists.